I hope we're live. It's taking time a little bit. So let's check our questionnaire. Please answer the question, where are you from? Okay, so we are live. Okay, I think everything is working, so we can start. So hello again, hello everyone. Good evening to everyone. Today we are going to discuss World's Intellectual Property Day. We're going to celebrate this very informational and very important day with our beautiful guest from US Embassy, Jamie. And before I will head to the speech and our speaker, let me share our screen. And also, could you please mute your microphones until our speech will be done, so everything will be quiet and nice. Thank you. Okay, again, hello. My name is Aigerim. I'm the coordinator of Makerspace at American Corner and Makerspace in Nur Sultan, and I'll be your host today. So enjoy your time here. Could you please write in the chat? The black screen? Mm-hmm.
Yeah, it's just a black screen. I don't see anything actually on the screen. It just says I'm viewing your screen, but I don't see anything. Let's see. Oh, there it goes. There it goes.
Okay.
There we go. All right.
So let's go. Jamie, could you please start?
Okay, sure. Before I begin, just a little bit about myself. First, a bit of a disclaimer. I am not a lawyer. I am in the United States. There are entire fields of law on intellectual property rights. I am not a lawyer. I am not an expert. So please bear with me in that regard. I have been in Kazakhstan since September of last year, and I'm an economic officer. Before I came to Kazakhstan, I was in Guangzhou, China, Taiwan, and then also Addis Ababa, Ethiopia. So this is my first time in the region, and I'm very happy to see everybody here today for this talk on World IP Day. So as mentioned before, the topic today is going to be how essentially how we protect intellectual property rights in the United States, with a specific focus on small and medium enterprises. If you want to go to the first slide. Okay, so in English, we often just say IPR. It's quick, it's easy, but that means intellectual property rights, and there are different types. Perhaps the most common that you've heard of or you are familiar with is patent and a copyright. So each type protects a specific type of idea or material. So a patent protects inventions. So for example, the COVID vaccine, those are generally patented, right? And that's an invention. A trademark protects a brand name or a logo or a design, you know, associated with that brand name. A copyright, which again is the other big one that most people know, that's specifically for original artistic and literary works. So a book or a painting, a movie, things like that. And then one you'll also sometimes hear is trade secrets, which they protect confidential information. So for example, a famous one in the United States is Coca-Cola. The recipe for Coca-Cola is a trade secret. So that's something that they protect very heavily. And in theory, no one knows what it is except if you're within that small group. So, so that's what we mean when we say intellectual property rights. All right, if you want to go. Okay, so why does this matter, and how do small and medium enterprises benefit from these protections? If you have IPR, if you have a patent for your invention or copyright for your book, then you have exclusive rights to those products, and you can use those you can sell them, sell the products, obviously. You can enforce your copyright or your patent, so no one else can do it. You can actually sell or license the patent or the copyright. I'm not sure if trademarks as well. A lot of this is overlapping. They overlap. So you can make money off of this, and that's why it matters. Going specifically to copyrights, one of the things that I am aware of is because a copyright, and I'll go into this in more detail in a minute, because a copyright is automatic from essentially the moment something is tangible, the moment you finish writing that book, the moment you take that photo, you finish the movie, it's an automatic protection. And when you have that copyright for that artistic work, when you then want to go to the bank and get a loan for something for your business, you can say, I have this, it's of value. So it becomes an asset, and that's important. And again, you can use it to increase your income because you can sell it, or in the case of a book or music, if it's used, maybe you receive a royalty, things like that. And it allows you to expand your market. You can market your product in other places and still have these protections. So it's actually very, very important. And when I say small, medium enterprises, small could be one person. It could be the artist themselves. So for obvious reasons, it's very important that you're able to protect your work. And one of the things for patents that frequently comes up in the United States is for pharmaceuticals. Patents for pharmaceuticals are very important, right? Many companies invest billions of dollars in researching, and they get that patent, and they get to keep that patent for a certain amount of time. And then generic drugs come out, but they make that money back. That's how they get their profit. And the argument is, if you don't allow them to patent, or you don't protect these patents, then no one's going to research these pharmaceuticals, right? They're not going to invest that money. They're not going to invest that effort. So by protecting patents and copyrights, pretty much, I mean, trademarks also, but more, I think, patents and copyrights, you incentivize people to actually innovate and research and create, because they don't have to worry that as soon as they do it, someone's going to steal it and make money off of it. So, okay, next. And I'm aware that most of the people listening today, this is kind of like English practice. So I'm trying to speak as clear as I can and as slow as I can. And if there's any terms I use in the question, please feel free to ask me to clarify at the end. This does get a little technical. So in the United States, when you want to file an application for a patent, say you came up with this wonderful new invention, I don't know, it guarantees children go to bed when you tell them to go to bed, and they instantly go to sleep, and it's not drugs. So say you came up with this great invention, you want to patent it. Where do you go? In the US, there's the US Patent and Trademark Office. And actually around the world, we have people from this office that are in our embassies and help us with these issues. So sometimes you'll run into these people that work on this specifically overseas. And so what is this? So patent protections are actually part of the US Constitution. So from our very founding, we've thought they were very important, and has been something that we've had laws to enforce. So the US Patent and Trademark Office was actually created in the early 1800s, and it moved and it was given different names. Currently, the USPTO, as we call it, it's within the Department of Commerce, which makes sense, right? In order to file So if you want a patent, you have to file an application. In order to do that, you do it with this office. Now, as I said at the beginning of this presentation, there are entire fields of law dedicated to this because it's very, very complicated. And so most people will choose, or most businesses will choose a lawyer. Or there's also things called patent agents, which are a little different. Because they're specialists and they're experts. But because this is so complicated, only patent attorneys and patent agents that are registered with USPTO can actually offer that service. So it's very regulated. It's not just anybody that can do it. And this office receives about 500,000 applications a year. And what they do in very, very basic terms, they receive the application. Depending on what the application is for, they'll send it to different, they have centers throughout I believe throughout the United States. And they'll send it to a center that kind of deals with whatever that particular item is that they want the patent for. They'll research to see if that already exists or what exists, and then they'll process it, and they'll either approve the patent application or they'll deny it. And so that's that process, and there are fees involved. It's very complicated. And just even for me researching the specifics on how to do this for this presentation, it's very, very complicated. So you can see why most people would hire a lawyer. Now, trademarks are a little bit different. Now, trademarks, kind of like copyrights, they're automatic. So once you have a trademark together, a logo for your company, once you start using it, it's automatic, it's yours. It exists. But the thing is that that automatic protection only protects you within that area, that geographical area where you sell the item. For example, your magic device to help kids go to sleep, if you are using it under your trademark, but you're only selling it in Texas, it'll only be protected in Texas. If you want it to be protected throughout the United States and even beyond, depending on where you want to sell it, you have to actually register the trademark with the USPTO to do that. And that's not automatic. And the process is somewhat similar to the patent. I don't want to get too much in the weeds, but that's what they do. If you want to move on. Okay, so what if you have artistic work, you have a painting, you have music, how do you protect it? What is that? So like I said, a copyright is automatic. As soon as you put something in tangible form, words on paper, etc., it is copyrighted. But what a copyright does not do, it does not protect the facts, ideas, systems, or methods of operation. So it doesn't protect other people from writing about the same thing that you wrote about. It just protects your work from essentially being copied. And so it's really interesting. So copyrights are automatic, but they also expire automatically. Whereas patents and trademarks, you can keep filing applications to keep the patent or the trademark active. You have to maintain it, otherwise it will expire. In the case of copyrights, they automatically expire after a certain amount of time. So for example, if this person wrote a book, the copyright would then expire 70 years after that person dies. Makes sense, I guess. So then if you have two people that work together on something, they're joint authors, it would then expire 70 years after the death of the last person. So whoever survives, it'd be 70 years after that. And if it's if it's a work that's anonymous, they don't know who created it, or it was done under a pseudonym, a fake name. So again, they don't really know who created it. It'll either expire, this is complicated, 95 years after it was published. So if it was a book or a song, it would expire 95 years after that, or 120 years after it was created. So if it was a painting, the copyright on that would expire 120 years after it was created. So that's how you can see things like classical music or classical literature, things like that. Often those things are not copyrighted anymore, those specific originals. Now, renditions of those originals might be copyrighted, but the originals are not. And likewise, if you want additional protection for your copyrighted material, you have to register it so that the US Copyright Office knows. So for example, if somebody takes your book, copies it, calls it their own, they're selling it, it's a clear copyright infringement. You can't file in the United States, you can't file a lawsuit against that person unless your work is copyrighted and registered with the US Copyright Office. So that's where the actual protection mechanism kicks in. If you want to go to the next one. So why, the United States is actually interesting because my understanding, and I'm sure somebody can correct me if I'm wrong, is that we actually annually receive the most patent applications in the world. And as you can see from this chart here, it says international innovators prefer the US. And this is from 2017, or no, I can't. Yes, 2017. But you can see how we compared versus other similar countries with IPR protections. And we received over 300,000 from people that are not in the United States. So why would you want to register your goods, you as an individual or you as a business, in the United States for patents or copyrights, etc.? Why would you want to do that? This other graph, and going a little backwards here, this other graph, it says U.S. Intellectual Property Rights Sub-Index 2020. And this is from an organization called the International Property Rights. They put, I believe it's an association, they put together an index every year, looking at each country in the world, their laws, how people perceive internet IP protection. So how much do people think the government will actually respect this or enforce this? How prevalent is copyright piracy in that place? And based on that, as you can see, overall, the United States is ranked number 2 as far as more or less best places to have your IP registered. Both with regard, we have a very high perception of IP policy or protection because our laws are very strong and we enforce the laws. Same thing with patent protection. Copyright piracy as well, it's very low. We're ranked number 1 in the world. It's very low, again, because of our laws. We have very strong laws that we enforce, and a low perception of corruption, a low perception of weak rule of law, which in some countries they may have good IP laws saying you can't infringe on copyright or patent, but they don't enforce them, or the courts maybe are not they're corrupt. So you don't believe that you can actually protect your rights. So that's one of the reasons why often people prefer to patent their goods in the United States. And just because you patent it in the United States doesn't mean it automatically is protected in every other country. There are a number of conventions that the United States is a part of, where in some cases it is automatic with copyrights, for example. Patents are a little bit more complicated. But often if you copyright it or patent it in the United States, because of its membership in those conventions, it's easier to then do it in other places if you want to sell it in other places and protect it. So, okay, do you want to go to the next one? Or is that the last one? I can't remember.
I think this is the last one.
That's the last one. Okay. All right. So again, very basic, very general overview. So if you have any questions, I'm happy to try to answer them.
Yes, guys, please, if you have any questions, you can write them in the chat, or you can unmute yourself and ask the question directly through your microphone. Okay, while everyone is thinking about their questions, I have a question for you, Jamie. I've seen this symbol of the circle, and the C is in the circle, and I've seen that many people use that to quote someone or to just put it on their digital picture on Instagram. Could you please describe or tell us what is this symbol really is? What does it mean? Is it a copyright symbol or just a...
Right. So if you see it with a C with the circle, that means copyright. And my understanding is, legally speaking, I mean, of course, you can always type that, right? But legally speaking, that means that it's been registered copyright. That's my understanding. So, and also then if you see TM, that means trademark. Same thing. It's been registered. I'm trying to think what the other one is. Sometimes you'll see SM, which is service mark, and that's for services. But let me see real quick. Yeah. Yeah, so I'm sure there's others. I can't think of other ones sometimes you'll see on products. But usually, my understanding is, legally speaking, for that to mean anything, it means it's been registered. Looking here to see if I see anything like that on here, but I don't see it.
So basically, when people put that symbol on their, Instagram post, it doesn't mean anything, right? It just...
Probably not on Instagram. But who knows? Maybe that person is really, because like I said, with copyright, so if it's Instagram, I'm guessing it's copyright because it's probably a photo. It's an automatic copyright. So they might have, especially if that's their brand or their business model. So
I have a question.
I think there was.
Sorry to interrupt. Can I ask a question?
Yes,
First
sure.
of all, hello. Yes, so my name is Diana, and I want to ask a question about, can non-US resident own copyright while being in US? Where is there sort of regulations or technical problem? Can you hear me?
Yes, yes. So can non-US corporations do?
Yes, like can non-US resident, like for example, if I'm non-US resident and I go to US and I want to own copyright, so can I get the copyright while being in US without being
own a copyright?
Yeah, yeah.
To my knowledge, yes, because you can sell copyrights. And you can, but again, copyrights expire. So probably you would be trying to buy a patent for something. If unless it was a copyright that still had a long period of time on it and it was a very lucrative copyright. Yes, I believe so. The only thing, this gets into a legal question. There's probably laws around it, but if it's registered with the United States, USPTO or the Copyright Office, yeah, I mean, you can do that. You just have to file the paperwork, get lawyers involved.
I see. Thank you.
Yeah.
Okay.
Thank you. And I see there's also a question, is there a representative or branch of USPTO at the U.S. Embassy, Astana? No. Sorry, my son. No, there's not. I don't know if there used to be, because the positions change sometimes. So it's possible to have that now and not have it previously and vice versa. No, to my knowledge, trying to think now. No, we don't have that here. And as far as our consulate in Almaty, I don't believe we have that either. Our USPTO, I know, right? Our USPTO is, I think the closest one to us is Kiev, if I recall correctly.
Thank you. Another question. Is there, it's regarding to the question that Diana asked before. So as an international person who wants to protect his rights on some item, maybe a digital, I don't know, artwork, is there any difference in US law if the person is like wanting an international protection, or it's only regarding to US Constitution, so there like no difference between that?
Right. So if you out, please out, go on, go. Sorry, the mother and me can't handle it. Close the door, please. So if you register with the US, it falls under US law. So if you register it as a US copyright or a US patent, it falls under US law. Now, WIPO also does have some patent and I believe copyright programs and databases, but to my knowledge, there is no one organization for you apply there and it's protected everywhere in the world automatically. To my knowledge, there's not that. It's based on the jurisdiction where you apply for the patent or the copyright. Again, I'm not a lawyer, so it's possible I'm wrong, but I don't think I am in this case. Yeah. So.
Thank you. Guys, do we have questions? I have a question to
speaking slowly enough.
Actually, like, is there any law student here who is currently studying law or maybe international policy? Like, do you have any comments about how copyrights are protected here in Kazakhstan? Because to be honest, I don't have a clue about what kind of rules and restrictions do we have regarding to this. Okay, I don't think that we have a law student, but maybe someone who heard about what kind of restrictions we have here. Okay, I think no one knows because I think that's the the biggest reason why we are discussing this today, to bring some awareness about copyright and property rights, not only in the US, but also to think about what kind of rules and restrictions we have here in Kazakhstan. So after our meeting, you will have a little homework. Please look up for some information about this and maybe write some posts or stories about your findings. What did you find, and are they similar to US, or is there any different? So Jamie, is there any, oh, we popped up a question. Are USPTO resolutions or orders legally binding only on US mainland, or does it also include other US territories like Hawaii, Alaska, and others? A very a very complicated question.
Actually, it's pretty simple actually. So for example, our copyright, our IPR laws are federal laws, and yes, that only applies within the United States, or pertaining to things that are registered or patented in the United States. Now, USPTO itself doesn't, it's not a court. So what it does is they're kind of a repository of all the patents, all of the registered trademarks, and then the Copyright Office, which is a branch of the US Library of Congress. Yes, they do the same thing. They're the repository. And so what they do is based on the application, they can determine if you can successfully have a patent. You can't patent something that's already been patented that is currently patented, because again, it can expire if you don't maintain it. So they can do that. And if they decide that what you're trying to patent already has an active patent, they can refuse it, then deny it. And you can try to challenge it, but there's only so much you can do. I don't know that you could take them to court for it, but there's internal procedures. In the United States starts copying it and selling it, you can sue them in US court. And that's where, that's a key thing too, is if it's registered with USPTO, you can sue them in federal court. And there's been cases of that. I mean, it's very common, like people do it. It's a very robust procedure. And that's, it becomes a little bit more difficult when, for example, your good is patented in the United States. Nike shoes, for example. That would okay. Let's say Nike shoes. This is a very complicated example. I chose a bad one. Nike shoes in the United States, it touches on all sorts of things, right? Trademark, patent. Maybe they came up with a brand new shoe for something, and maybe it's super flashy and beautiful, and so you've got copyright too. And then somebody in another country starts manufacturing the exact same thing, calling it the exact same thing. It's clearly not. So they're infringing on all sorts of things. That's when it becomes really difficult. And that's one of the reasons we have USPTO officers overseas that help deal with this. And ideally, we would work with the local government, if it's brought to our attention or if we're aware of it, and help them deal with it. We're not the international police. We can't just, we work with host governments to try to resolve the situation. So, but yeah, again, I'm not a lawyer, very technical. I'm just trying to answer it hopefully as accurately as I can. Now, where it sometimes does become more international is, like I said, the U.S. is part of a number of conventions. Like, for example, for patents, there's the Paris Convention that it essentially, and that's like 176 countries and that are part of that treaty. And it's the Paris Convention for the Protection of Industrial Property. And what that does is each country that's a party to that treaty, it gives, they guarantee to give the same rights, like patent and trademark matter, right? Like protections to foreign citizens as they would to their own citizens. So they don't discriminate. And what that means is, for example, going back to my bad example about Nike shoes, if where the infringement is happening is a country that's a party to that treaty, that country government will probably enforce that. I mean, it's an infringement case and they'll probably work with us on that. But again, very complicated. Yeah, thank you. Anybody else?
Thank you. So we have a question. Someone texted me for like personal text. Do you recall any big cases of a violation of IPR? For instance, several years ago, we had Kazakhstan Kpop. So is there any big cases that were very popular and famous in US or maybe around the world?
So the only thing I can think of off the top of my head that other people listening to me right now might actually, which then had to close their product. That's harder. I can't think of any examples of that off the top of my head. The most relevant example, though, I can think of is actually pretty recent. At this year's Grammy Awards, a Kazakhstani artist won a Grammy. And the Grammys, for those that are not familiar, is kind of like the Academy Awards for music in the United States. It's a very big honor to receive an award. And yes, and
Okay.
yeah, and this is, this is great. But apparently the gentleman that had won, this Kazakhstani artist who had won, he the music that he had won for, the song, he actually infringed on the copyright of, he did a remix, I believe. I think it was a remix. I don't think it was just a cover. I think it was a remix. I'm not as familiar with the music, but it was originally by an American artist, and he infringed on the copyright and produced his own video, and it went on the internet and became very popular. And so apparently it was an issue because, for obvious reasons, if he wants to commercialize that beyond what he was doing, they're going to have to resolve the copyright issue. And so my understanding from what I read in the news is that an American music label signed him on as for a contract, and they had to pay, I'm guessing it was restitution. They probably had to pay money to the original artist to compensate them for infringing on the copyright. So, he was able to be very successful initially by infringing on the copyright, but ultimately he still paid for it. He paid financially for it. And that's common a lot of times, because again, you're suing somebody. If it comes to that and you go to court, you're suing them for either compensation or for an action. So either you want money from them because they profited from whatever it is that is yours, your product or your idea, and you want money to be compensated for that, money you lost because of that. Or in the case, which, this happens fairly frequently, maybe the company doesn't want the money. Maybe it's a big company and it's just this little bitty person or entity in another country or even in the United States doing it. And they're like, we don't want the money, just stop doing it. Stop manufacturing it, stop infringing, shut down. And that happens too. And so yeah, I haven't heard his music though. I have to be honest. I have not heard his music. I guess it's very popular though, I guess. So Imanbek, am I saying that correctly? Imanbek, yeah. So.
Thank you. We have another question. By whom the USPTO funded? By the government or by the private sectors? Very interesting.
So yes. So the USPTO, it's a government agency. Well, I say agency, that might not be technically the correct word, but it's within the Department of Commerce. The Department of Commerce is an agency of the US government. So it's kind of like a wing of the Department of Commerce. So it's government. They're government, just like me, funded by the government.
So I have a following question to this, to previous question. When the copyright is expired, for example, it's a artwork or maybe a traditional song. So who is the owner then? Is there any regulations to, I don't know, deliver the rights to his relatives or her, maybe to the family, or it will be just like a national heritage?
That's a really good question. To be honest with you, I'm not entirely sure how that works with copyright when it expires or when it comes to expiring. Yeah, because I know, for example, like patents, if the person that owns the patent dies, then the patent is part of their estate, and so the family can inherit it. That I know. Copyrights, my understanding is this the same thing? But only within that span of time after the person's death. Like I said, if it's one person, one author, one photographer, it's good for 70 years after they die, the copyright. So the owners of that copyright would likely be the family, the surviving family, for example. But when it comes time to expire, I don't know. I'm not aware of a mechanism to keep it from expiring. Yeah. Yeah, I'm not aware. If there is one, that would be good to know, but I'm not familiar with it.
So I was asking this question to know, for example, there are many fashion brands, fashion companies, like Valentino, or I don't know, Bottega, Balenciaga, and are they are copyrighted, or are they how do they deliver this trademark, maybe how they protect it? Is it under a private company, or in case, for example, if it's a very, very old brand, is it considered as a national, I don't know, heritage or something like that?
Yeah. So, okay. So you have a couple of things. You have trademark. So for example, Gucci, the trademark, both the name, but also like their actual logo, the design. That, as long as that's registered and they maintain that trademark, it exists. And my understanding is it doesn't expire as long as it's maintained. And by maintained, I mean you file paperwork periodically every few years based on the schedule, you pay some money, that kind of thing. So that's that. And that's fairly simple. Then you also have copyright, right? So you have the actual clothes that they make. So say their fall season wardrobe. Yeah, I mean, that's an artistic, I mean, I think it's an artistic work, if you will. And if somebody, yeah, and if another company, for example, takes it, makes the exact same thing, and then sells it under their own, depending on who it is, I mean, I imagine it would have to be a pretty big deal for them to get involved. The other thing too, I think that's important is if somebody's doing something, but they're not monetizing it, it might affect things as well. But you can't, it's not like you can just give it away. You can't steal somebody's intellectual property and give it away. It doesn't work like that. What I mean by that is if you are doing it, for example, I'm painting at home and decide to paint a recreation of somebody's famous artwork that's copyrighted. That's, and I'm not doing anything with this. I'm not selling it as my own. I'm not doing anything like that. That's one thing. It's when you're monetizing it or you're giving it away and depriving somebody of the financial rights to that good is what's really kind of the key. Not to say it's okay one way or the other. I'm just saying in the laws, that's my understanding.
So we have, thank you very much. We have few minutes to final questions. Please, guys, if you have any questions, don't hesitate, don't be shy, ask your questions.
Yes, I promise your English is better than my Russian, I promise. Much better than my Kazakh.
Do you know Kazakh?
I knew someone was going to ask me that. No, I don't know Kazakh.
No, you don't.
I barely know Russian. Let's see. What about using copyrighted things for reference? I'm not sure. I'm not sure I understand. Yeah.
It's in case when you are, for example, studying, you can use someone's beat to, I don't know, learn how to do or copy that and learn by copying. It's very spread in the artistic world. when you just copy someone's, for example, when you see Mona Lisa and you want to try oil paints, and you use it as a reference.
Yeah. So this kind of goes back. Yeah, it's a bit of a gray zone for me personally. When you're doing it for yourself and you're not trying to monetize it, and you're practicing, versus if you're trying to sell it and claim it as your own. It's a gray area for me, and so I don't know exactly. Now, one thing that this might be kind of running in with is something we call plagiarism, and plagiarism is a type of infringement, and what that is say you love the poetry of Edgar Allan Poe, a very famous American poet, and you copy his poetry and you claim it as yours, and you put your name, and you might change a little bit, but it's still very clearly his. That's plagiarism. And depending on the circumstances, I mean, that's against the law, that's a problem. And sometimes you'll hear about it in academic circles, like maybe a researcher plagiarized someone's research, or plagiarized someone's writing to do something. And one way we get around that is if you're referencing it and you're not intending to pass it off as your own, but you're referencing it, is we will cite it, or we'll provide a citation. If you look at for example, if you look at my screen here, or my slide, I think I can still see the slide. I hope everyone else can. These are graphs, and these are, this is data that's not mine. I did not create this. And so at the bottom, it says where the source is. It shows you where the source is from. I'm not claiming this as my own. I'm telling you where I'm getting this, but I'm still using it as a reference, right? So that's different. I'm not trying to monetize it. I'm not trying to pass it off as my own. So in plagiarism, in American culture, especially, plagiarism is very, very much looked down on. It is not accepted. It is a very big taboo, I would say, in U.S. culture. And I know in some cultures overseas, it is not. It can be viewed as flattering, or as not a serious problem. I believe in the U.S. culture, it goes back again to our heritage. These protections are enshrined in our law from a very, very beginning. So in our culture, we really do value these protections quite a bit. So.
Okay, thank you. And last question, I have a last question. I was thinking about it from the beginning of our meeting. Is there any, I don't know how to even describe it. So there is a thing in K-pop, in Korean pop, when people can take a picture of a celebrity and then make some stuff out of it, merchandise or something like that, and sell it. And there is a big, serious problem in that area, because those pictures are spread on the internet very quickly, so no one knows who is the author of these pictures, or who's the real owner of the merch that was sold. So is there any thing that you can call a trademark, or maybe a copyright, for a human's face to be protected for that from that?
Oh, that's super complicated. Yeah, because we also have privacy laws in the US. So depending on where the photo was taken, like for example, if I'm in my backyard and it's clear that I'm in my own space, that I have a certain expectation of privacy. And if somebody, takes my photo during that and then tries to sell it, I mean, that's one issue. It becomes another issue if I'm in public and somebody does it. Yeah, that's really complicated. I don't actually know. I'm not famous, so I don't have these problems. No one wants to monetize my image for some reason. No, I don't know, because I think you could also say too, depending on what is being done, it could also be infringing on their trademark. Because if somebody's a model, for example, maybe they're, I don't know if you can make a legal case that their appearance is their trademark. I'm not really sure. Yeah, that's hard. I don't know. Yeah, because I know there is, you know, people try to trademark words or copyright and like a word, and it gets very, very gray. And again, this is why we have an entire industry devoted to doing this, because it's so complicated. So I'm sorry I don't have a better answer for you. Yeah, I think it kind of, yeah, I think it depends on where the photo is taken and then what's being done with it. But I'm not sure you have a lot of options. If somebody takes your photo while you're walking down the street and does something with it, I'm not really sure. Yeah, I don't know. That's a good question. I'm curious now. I'm not sure. I'll have to look into it.
Yeah, I was really also discouraged, or how should I describe it? I was interested like how celebrities deal with that. Because I saw even American celebrities, they can't, you know, deal properly with this problem when someone is selling stickers with their face, or some like merchandise with their movie where they were, like something like that. So I was just curious about it. If we don't have any additional questions, I think it's time to wrap up and end our today's meeting. So do we have any questions from our audience?
Who earns the benefits for copywriting pieces of a RT? Oh, of art. Sorry, I got cut off. So the author, right? So if I write, or if I paint a painting, once that painting's completed, I sign my name. I'm the author, or I'm the artist rather in this case. I benefit. So it's my copyright. And if I want to make copies of the painting and sell those copies, I get the money. Someone couldn't then, and if I register that copyright, so it's good all over the United States, and copyrights are a little different. My understanding is that there is some more international protection with regards to copyrights. You know, so somebody else can't just then do that and start making money off of it. I could sue them, is what I'm trying to say. I could sue them. So, for very old ones. So yeah, so if once a copyright's expired, yeah, like Van Gogh, yeah, that's a good question. It's whoever does it, right? It's not copyrighted anymore. My understanding is once something is not copyrighted anymore, it expires, like a Van Gogh. You know, they, yeah, whoever creates something with them benefits from it. Why many videos on TikTok and Instagram with music of some artists are taken down often? I think it would depend on the music. If it's music that's under copyright, then they're infringing on the copyright. They would have to pay a fee to the musician or the creator of the music. If it's music that is not copyrighted, for example, Mozart or Beethoven, they can play the music, right? But if they're using someone else's recording, the recording might be copyrighted, right? So there's different layers of it. So the actual song itself might not be copyrighted, but the recording might, because that's somebody's work, right? An orchestra that's doing it, that's someone's work. But again, it gets very, very complicated. But that's my sense, is if they're taking it down, it's because either the music is still copyrighted, the music itself is copyrighted, so they infringed, they should have paid a licensing fee to use that music, or the recording of the music. In the case if it's like a really old song, the recording of the music is copyrighted. There's different types of copyrights. Yeah. So
I think no one wants to end this session. Everybody asking questions.
How is plagiarism of work, for example, my essay, being calculated on websites and internet? I'm not sure I understand the question. You mean like how can you, yeah.
So there
Sorry.
is some tools or websites you can use to check your essay for plagiarism. For example, if there is any repeated words or even phrases or maybe data that you took from someone's work, it could be, for example, a motivation or cover letter or something like that for university. So how does this calculation works?
How does the software work? I see. I have no idea. I really don't know how that works. I know my sense is it uses an algorithm to detect patterns of words. And obviously it's linking back to some kind of database that has those patterns. So I imagine too that there's certain things that are commonly plagiarized, and it probably links to that. But I'll be honest with you, I don't know how they work. I know they work in the United States. If a student is caught plagiarizing, like in college or university, they'll probably at a minimum fail the class. They might get kicked out depending on what it is. So they do work, but I don't know how they work. Oh, it could be a good might be a good research project. Yeah, no, I know personally when I was in university, I was always very paranoid about being accused of plagiarism because again, in the United States, in our culture, it's very shameful to plagiarize. I mean, it's a big deal when somebody catches you plagiarizing. And so we cite everything, and usually there's different ways you can do it. It can be either in the back, at the end, or at the bottom. It just depends on the style of writing you're doing. But when in doubt, cite your sources, and you probably will not be accused of plagiarizing.
Okay, I hope everyone has asked their questions. Yeah, it's time to wrap up. Thank you everyone for joining us today. Thank you, Jamie, for your presentation. It was really interesting and informative because as you can see, not everyone knows about rules and regulations here in Kazakhstan about IPR. So that will be our homework for today, to search the internet. Yeah, thank you.
Thank you, everybody. Thank you for listening to me and for asking good questions.
So it's the end. Goodbye, guys. Thank you. Have a nice evening.
Thank you.